Hi, good afternoon. This is Jen Ritter-Tomasic. Thank you so much for joining us for our second session of our Community Association Building Block webinar series. Today's session will cover the topic of land use and zoning issues. Again, I'm Jen Ritter-Tomasic. I'm Marketing Coordinator of Events and Proposals at Borden Smith, and I'll be your moderator this afternoon. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options, then choose side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers today are also happy to take questions. If you have a question, please type it in the Q&A box and it will be addressed at the conclusion of the presentation. If you give me just a moment, I will share our slide deck. Okay, so let's get started with speaker introductions. Today's speakers are Adam Bowden and Clint Cogburn. As leader of the Community Associations practice, Adam advises community association and country club, yacht club boards and members regarding corporate governance, procedural requirements, governing document amendments, fiduciary duties, inspection right, collection issues, and rule adoption and enforcement. Also joining us today is Clint Cogburn. Clint represents clients facing a wide range of challenges in the areas of litigation, community associations, and zoning and land use. Clint devotes a portion of his practice to helping clients navigate zoning and land use issues, such as subdivision of property, zoning and rezoning matters, special use permits, conditional use permits, variances, appeals of the interpretation of zoning ordinances, certificates of appropriateness, developmental approvals, and development agreements. Now I'll turn the mic over to Adam so we can begin.
Good afternoon, and thank you so much, Jen. She is our cruise director, and we're very, very fortunate to have her. So she's going to make sure to keep me straight and make sure the star of our show, my law partner, Clint, has everything he needs. So thank you, Jen. And thanks to everybody for taking a little slice of their day out to hear about the exciting world of community associations and land use, which for those of us that are kind of community association geeks or nerds, which I'll just speak for myself, I actually think it's pretty interesting. So I'm excited about this one today as well. So whenever I speak, and many of you have seen me in the past, I'm sure at CAI events or virtually, I always like to start at the top, right? Which is, let's start with the laws that govern community associations, just to kind of set the tone for today. And so this next slide here basically sets out the federal and the state laws that are going to govern your community associations, right? And that's going to drill all the way down to your municipalities, okay? That is your towns, your cities, which is a lot of what Clint's going to be talking about today, but we'll take it from the top, right? So the important federal laws that we need to keep in mind are the Fair Housing Act, the FCC's regulations on over-the-air receptive devices, and the Fair Debt Collection Practices Act. And when it comes to zoning and it comes to land use, the Fair Housing Act is just something to keep in mind because it prohibits discrimination against familial status, and that means families that have children 18 and under living at home. So sometimes we, in our travels with internal conflicts, we'll see that homeowner associations want to they don't like that there might be grandkids living with grandparents and things like that. You have to be really, really careful about those things. And so that's not a big topic for today's discussion, but just wanted to let you know what's out there. all community associations in North Carolina since 1999 have to be incorporated under the Nonprofit Corporation Act. And there are a few fun ones that we deal with called unincorporated associations. And the way that zoning and land use applies to them is no different than an incorporated association, but just kind of wanted to set the table on that. Then if you're a condominium, you're either governed under Chapter 47A or you're governed under Chapter 47C. 47A was created way back in the early 70s when the state of North Carolina's legislature believed that you could only have a single condominium building, that you could not actually create a condominium that had multiple buildings with multiple units in them. And I say that in jest because that of course is not the case. Most condominiums are multiple buildings with multiple units. And so that's why in 1986, the North Carolina Condominium Act came into play. Obviously, condominiums are different from the planned communities under Chapter 47F because that is multifamily housing versus single family. And Clint's going to talk a little bit about some of those things when it comes to zoning and rezoning. Most property will have to be rezoned for multifamily if it's a single family use to begin with. And so that's just to kind of set the table on what we're talking about. And there may be some different issues depending on if you're single family or multifamily. So now that we've gone through the federal and state laws, it's all about the governing documents that your community has. And I'm not going to spend a lot of time on this because I said I'm not the star of this show, but these next 3 slides show the hierarchy of the governing documents and how they apply to your community. And we always start at the top of the mountain, which is the declaration. Okay, this is the document that gets recorded at the Register of Deeds that creates restrictions. It binds the dirt, if you will, right? It goes hand in hand with the zoning and the ordinances in that particular jurisdiction. And so this is the document from which all authority springs and the creation of the community. And so it will say, hey, we're going to have this thing called the Homeowners Association that's going to administer these rules and restrictions and collect your assessments and do all that fun stuff. On the next slide, you'll see it begins with the bylaws. And the bylaws are an internal document governing your association, which really has nothing to do with zoning or ordinance other than how your board deals with zoning and ordinance challenges, okay? And so then finally, we have the least important and the least valuable when it comes to these things, the board resolutions and your rules and regulations on the next slide here. And so just remember that that you can't adopt rules and regulations or board resolutions that are inconsistent with your declaration. And so that brings me to the next slide, which is my favorite slide of all. I'll wait for it to come up. So this is one of my pet peeves, right? I speak a lot nationally around the state. I'll ask people to raise their hand and tell me what are the purposes of your homeowners association. And so these are the purposes, right? To manage, maintain, repair, and replace the common areas, common elements, and to follow the governing documents. The reason that this is so important for you to have this in your mind for today's discussion is because whenever you're dealing with zoning or ordinance issues, whether internal or external, and Clint's going to talk about both, you have to come back and circle back to the purposes of the association to make sure what it is you're trying to accomplish with regards to zoning or ordinance, or maybe that parcel next door, are consistent with these 2 purposes, right? There is no third bullet that's going to pop up here that says, oh, maintain property values, increase property values. That's not a purpose of a homeowners association, okay? Now, I do know, and if you've heard me speak before, by doing items 1 and 2, by keeping good care of the common areas and following the documents, yes, it should be a nice place to live and property values should be maintained or increased. But that's not the association's purpose. So make sure whenever you're getting involved in a zoning or ordinance dispute that it is true to these two purposes. And we'll do the next slide now, Jen. And I'm gonna turn it over to Clint. He is the star of the show, and I'm staying on. I'm gonna go dark. I'm gonna shut down my mic and my camera, but I'm gonna be here the whole time, and I'll be here to answer questions at the end. But he is your expert when it comes to this area of law. I'm just a traveler like the rest of you.
Thank you, Adam. Thank you, Jen, for helping put this all together. It would not be possible without Jen's extraordinary work. So definitely want to give her a shout out. And thank you to all the attendees. We really appreciate the opportunity to present to you today. We appreciate you taking time out of your busy schedules to join us today. And we hope that this is a beneficial experience for you, and that you learn some things along the way. As Adam said, in kind of laying the groundwork related to associations and association purposes, I'll be kind of guiding you through some of the common land use issues that associations face. We'll delve into how the association's work intersects with land use regulations, municipal regulations, and really some of the best practices an association can put into place to best position it when facing certain land use issues. As a bit of a guidepost, we'll begin with how to approach these issues and some of the ABCs of land use. We begin with those just to kind of give you a real baseline understanding of those. It's important to have that understanding before we get into more complex issues. We'll discuss some of the common applications and terminology you'll see along the way so that you're familiar with that. It doesn't scare you when it pops up when you're dealing with one of these issues. And then we'll conclude with those two issues that Adam highlighted, which are the external issues, which are commonly things like occupancy requirements, short-term rental restriction, leash laws, certain development standards for parcels within the association. And then external issues, which are more common, which will probably be the ones that you're most interested in. And those deal with, what do I do when an adjacent property has submitted an application or is looking to be developed? How do I best approach that? How do I best protect the association's interest in dealing with that development, whether it be looking to see if conditions can be added, whether it's opposing that application? We'll get into all of those. We'll first get into how to generally approach these land use issues. I want to highlight that because, again, I think a good foundation is important before we get into any of the more specific issues later on in this presentation. We also put this slide at the beginning because if there's one thing that I want you to take away, it is that first bullet point, which is defer to the municipality. Defer, defer, defer. I want you to hammer that into your mind. And again, if that's the only thing you take away, I've been successful. The reason that is important and that I harp on it so emphatically is that I know that associations can be aggressive in protecting their interests and enforcing the bylaws and the regulations of the association. And I'm sure Adam would say that we like an association to be proactive. We like an association to be aggressive in protecting its interests. But when you're dealing with municipal regulations and land use regulations, you are not the judge, jury, and executioner under that framework. Defer to the municipality. Let the municipality be the bad guy. They have an enforcement regime that they use. They have staff that enforces those regulations. So be active and be proactive in communicating with the municipality, but don't be aggressive in enforcing those regulations. Pass that along to the municipality and let them do their work. Again, don't be completely hands off. I'll touch later on the importance of having a good working relationship with whatever planning department you fall under, but again, defer to them. On the next slide, we'll talk about some of the real ABCs of land use regulation. And again, it's important to understand these and to have a good working knowledge of them, both so that the association can navigate some of these land use issues as they pop up, have a good understanding of what's going on, can address them as they arise. And then two, having this understanding will help you work with your legal counsel more efficiently. It will save you on legal fees if you know what is happening, if you know how to address this, if you know how to frame this up for your legal counsel. It will save them time. It will save you money. It'll make the process a whole lot more efficient. The first thing I want to touch on is just some of the basic terminology, which is which law applies to me, which law applies to the association. You're probably going to say, Clint, this seems very basic. Clint, how could anybody not understand which law applies? I can't tell you the number of times I've had clients come to me and not understand which municipal regime they fall under and which ordinances apply to them. It seems very basic, but it can get a little confusing, especially if you're new to this area. So we just want to touch on some of those. Broadly, an association will be subject to one of two municipal land use regimes. It'll either be subject to county regulations or city regulations. So you need to figure out which the boundaries of those jurisdictions. And if you're within the city boundaries, you fall under the city. If you're outside the city, but obviously within the county regulations then apply. You're probably wondering, well, there's a third bullet point there, Clint. What is ETJ, extraterritorial jurisdiction? That third point is important because the ETJ, although a fairly narrow concept, it allows a city or a town to manage and regulate development that is technically outside of its city or town limits. Depending on the population, that can be 1 mile outside, it can be 2 miles outside, it can be 3 miles outside, it can be it can be around all of the city limits, it can be around a portion of these city limits. So even though you may think that you are subject to county regulations, if you are nearby a city or a town, you need to make sure that you do not fall, or you at least need to check to see whether or not you fall within the ETJ, because if you do, you are subject to that city or town's land use regulations as if you were within those city or town limits. So we put that on there because, again, I've had clients say I'm in the county, and then you take a look, they're right by a city, and they are subject to the ETJ and thus subject to the city regulations. Step 2 of the ABCs is we want to look at what the actual law is, and we want to understand, again, some of these terms. We want you to be comfortable with these terms and the terminology, because if you're comfortable with them, you will then be able to use that knowledge to address more complex issues. So when you're looking into which regulations apply, you'll run into a number of documents. The first two are kind of one and the same thing. You will run into a city or county's uniform development ordinance. Similarly, it may be called a land development ordinance. And that will be where you will see the different regulations that a city, town, or county may put on developers and pieces of property. A few of those, just to highlight them, are use districts. So use districts are different types of uses that are allowed within a specified district. So what municipalities will do is they'll develop like uses or uses that seem to fall into a similar category, and those uses will be single family uses, multifamily uses, commercial, industrial, office. It'll vary from municipality to municipality, but a lot of them will be similar. And really just those instruct you what type of use is it. And within those use districts, you'll have what are called permitted uses, which are uses allowed by right. You'll have varying levels of uses permitted or prohibited in those use districts. So it's important to understand those use districts and what is allowed, because they inform both what uses are permitted and what the development standards are. Development standards are going to be things like fence regulations, signage, height, density. So it's important to understand that you need to look to the UDO and the LDO to figure those things out. One of the things within the UDO or LDO that'll be really handy, and I encourage you to download both your applicable UDO and LDO and have that handy, but also have handy what is called a permitted use table, which will outline all of those uses that are allowed in those districts, so that you just have that as a quick reference. It's an easy thing to reference, so you can, if something comes up, take a quick look at it. It lays out all of the uses permitted in all of the use districts. We'll next look at the comprehensive plan. The comprehensive plan is a prospective document. It's how the municipality wants specific areas, pieces of property to develop. It'll look to see, it'll lay out, it wants parks here, it wants greenways here. It's used as something to, it's used as a forward-looking plan, so that when dealing with present day zoning applications or present day land use issues, the municipality has some guide to inform it as to what is the town, the city, or the county looking to do in the future. And those applications for a rezoning or a change to the zoning of a piece of property have to be consistent with the comprehensive plan. So if you've ever gone through the rezoning process, you'll probably hear at planning board or city council meetings, they'll read into the record what is called a consistency statement. That is what is being referred to there, is that application is consistent with the comprehensive plan, is consistent with what that municipality has projected forward for that piece of property or that area. It is not specifically binding. Again, it's kind of more of a prospective document, but it's important that if you go through the land use process, or if you're filing a rezoning, or if you're challenging a rezoning, to make sure that you have some knowledge or understanding of the comprehensive plan, or at least have it in the back of your mind, so you can make sure that application is consistent with that forward-looking document. The final piece of law, or the final important thing to have some knowledge of, is the zoning map. And that is just something that you can access through the GIS system. It should be readily available, and it just lays out what is the current zoning of properties. You'll be able to see what a property is zoned into what district. You'll be able to see if it's subject to any other restrictions. It just gives you a snapshot in time of the designations for property. We'll now take a look at kind of who are the players, who's what I call the land use starting lineup. It's the people to know. And I can't emphasize enough to you that in dealing with land use issues, having good relationships with these people or knowing who to contact is probably the most important thing. These people can help you, they can help guide you. And if you're challenging a rezoning or an application, they're the people at the end of the day who are going to make the decision. So it's vital that you know them and have some kind of working relationship with them. So the first group is the planning, development, and staff. It's led by the planning director. The planning director is incredibly important, but I would say even more important is just having a good working relationship with the staff members. Obviously, if there's a specific application or development, it will be assigned to a staff member, and that person you will work with directly. But it's just good to know those people. They will be able to answer your questions. They will be there to help you. You will want to be in it. You want to have a good relationship with them. You don't want to be that person who's constantly pestering them or bothering them, or you get a bad reputation because although they're there to help you, as any of us know, if somebody is a little pushy, those emails and calls may not be answered as quickly. But have a good relationship with these people. They're there to help you. The next group is the Planning Board and Zoning Commission. These two are used interchangeably. It'll be, oftentimes it'll be one or the other. There are some municipalities who have both. I previously practiced in Greensboro. They had a planning board and a zoning commission, which was extraordinarily confusing at first, but this group, whether it's a planning board or a zoning commission, will be essentially the first body that hears a application or deals with a land use issue. It is the first body that will hold a public hearing on an application or a land use issue. And it really serves as a test balloon for that application and for any challenge. Typically, a planning board or zoning commission will issue a recommendation to the city council or the county commission. It typically won't make a final decision. I will note that's not always true. There are certain municipalities where, again, if you get a unanimous result in the planning board or zoning commission, that can serve as a final decision. But typically it's a recommendation. Again, it's the test balloon for a application and for a challenge. We then have the Board of Adjustment. The Board of Adjustment typically deals with more specialized, more complex land use issues like variances. We'll touch on variances here in a second, but you may run into them if you have variance issues. And then finally, we have kind of the main event, the people who make the final decisions, which will be city council and county commission. And again, it's just important to have a good knowledge of these people, the ability to contact them, and to have, to the extent you can, a good working relationship with them. So now we'll jump into some of the specific issues that you may face, some of these applications that you may see, and again, some more of the terminology. So a rezoning is a request by an applicant, which is typically going to be a developer property owner to change a property's current zoning from one of those use districts to another. This is a change that will allow for all of the permitted uses. It will be subject to just the stated development standards. And I say that because I want to differentiate what is known as standard rezonings, which is what we're dealing with here, with conditional zoning or conditional rezonings, which is what we'll deal with here in a couple slides. A quick procedural note on applications. You may get an application and say, I don't know who this applicant is. I've never interacted with this person. I've known the owner of the property that's being rezoned for 10 years. I don't know who this person is. It is not uncommon for applicants to be developers who are interested in purchasing the property. It's commonplace that the rezoning be a condition of the closing of the purchase of that property. So it may be that it is a new owner that is coming in. They will be the applicant. It could be a law firm that is the applicant. But please know that if you see that and you're concerned about it, that applicant has to get permission of all property owners before submitting an application. All of the property owners that are subject to that application. I want to clarify that. So if you get something and you're not sure who it is, that's probably what's going on. It's probably a developer that has agreed to purchase, and that is just a condition of the closing. Again, this is a request for a standard rezoning. Every district, again, has those permitted uses, has those development standards. And so it's important to, again, have a good familiarity with the UDO, with the LDO. And for standard rezonings and these conditional rezonings we'll get to in a second, it's important to know that these are legislative decisions. You'll hear legislative decision. When we get to special use permits, you'll hear quasi-judicial decision. A legislative decision is maximum deference to the municipality. The municipality is really, absent making a totally arbitrary decision, is empowered to make whatever decision it is, and it's really not subject to any judicial review. So they can make decisions based upon a variety of factors, community impact, community concerns, impact to property values, traffic concerns. It is a wide range of things that they can take into account when making that decision. It also, I'll let you know, it allows for more flexibility before a hearing on it, because it is not subject to certain ex parte restrictions on communication. So you can have discussions with town council members, city council members, county commission members, planning board members, and really have candid discussions with them and seeing where they are on an application or on an issue. We talked about very briefly there conditional rezonings, and I'm a big fan of conditional rezonings because it's a flexible mechanism for a rezoning. I think it's very useful. I think it's a way that a developer or an applicant can collaborate with surrounding property owners to better position an application. It's one that allows for a community to have input and say, we may not be per se opposed to a development, but we're very concerned about things like traffic. We're very concerned about the height of buildings. We're very concerned about the density. We're concerned about the parking. It allows an application to include additional limitations or restrictions that provide, probably a better sense of relief or security or comfort to the city or the town and to surrounding property owners, because they're subject to more stringent or strict standards than what is specifically provided for in the UDO or LDO. And so that's why I call it a standard rezoning on steroids. You'll oftentimes see conditional uses or uses that are conditioned down. They'll eliminate certain uses that are considered noxious or less than appealing. Oftentimes that'll be things that just don't fit with the character of the community. Other common conditions are conditioning access. So if something is located along a commercial thoroughfare but abuts a more residential drive, you can condition it so that access is taken off. It is only allowed on that thoroughfare, so that that traffic flow is taken off of that adjacent residential drive. Again, this is a legislative decision, so it's going to be maximum deference to the city, to the municipality. But you'll be able to have those discussions prior to the process and get a sense of what the decision makers are thinking, what may be possible. And then you can use that input to also frame discussions with a developer and maybe frame some of the conditions. The next common issue, or the next kind of terminology we want to look at, is variances. And this is where the Board of Adjustment gets involved. Again, it's a more specialized land use issue. And what it is a request to vary from a regulation due to undue burden and unfair hardship. This will typically be something like a fencing requirement, where if you are required to meet that requirement that a fence has to be X feet high, that you're impacting sight lines. That's kind of just a basic example. But it is a very, very high standard to meet. It requires unnecessary hardship that the applicant would incur if not for this requested relief. It has to be, that hardship has to result from the property itself. It can't be man-made. It has to be arising out of the property. And again, it can't be self-created. So it has to be unique to that property. It can't be something that's common to surrounding property, and it can't be something that the applicant has made or that a prior owner has created. Additionally, you have to show that you're consistent with the ordinance. They're not going to vary a whole lot. I'll also point out that you can't use variances to permit a use that is prohibited in a use district. Use variances are not allowed. So you can't kind of use that as a workaround if you have a use district that prohibits a certain use. Use variances are not allowed under North Carolina law. And so, as I say, as the slide shows, this is an incredibly high standard. It's one that if you are looking to apply for a variance, or you have a member of the association that is looking to apply for a variance, I would highly encourage getting counsel involved to perform due diligence on it. These will often be fairly expensive. And again, they're very nuanced and require a lot of specialization and understanding of kind of how to best frame that variance. The final group we have here is the special use permits, which I touched on. And you see there at the top that terminology of quasi-judicial decision. As we've seen throughout zonings, conditional zonings or conditional rezonings, and Board of Adjustment. Many of these are going to be legislative decisions. Those legislative decisions, again, are maximum deference to the municipality. They can take in a lot of factors. They can do research beforehand, and they can look at news articles. They can look at news reports. It really gives them a ton of flexibility in making a decision whether or not to approve or deny it. And because there's that much deference afforded to them, there's really no legitimate legal recourse if they go against you. Here, special use permits, it's different. It's a quasi-judicial decision that's kind of in between that legislative decision, the flexibility of that legislative decision, and the rigidity of kind of the court system. It'll look a lot like a judicial hearing. It'll be before the city council or the town council or the county commission. All of the all people wanting to provide testimony will have to be sworn in. There is formal testimony. Evidence is submitted into the record, and so it does have that process. And most importantly is that if you meet a certain set of standards or certain requirements, which I'll touch on here shortly, absent rebuttal, competent expert evidence against that, they are required to issue you the permit. So it's more rigid. It has more formalities, but the upside is that you do have this requirement that if you meet all of those, if you meet your burdens, they're required to issue you the permit. So it is a specialized process. It's typically for unique uses, high intensity uses, or significant impact uses. It's a way for the municipality to have greater control over those types of uses. Again, they have to show certain requirements. And so that's why they'll frame up certain uses or use types to require special use permits. And the applicant in applying for that has to meet certain standards. These standards can vary from municipality to municipality, but typically they'll be in, and there are four kind of overarching requirements. It's harmony of use, which is that use that is being applied for consistent with the surrounding area? Is it consistent with the harmony of that area? Does it differ significantly from what's already existing there? The second is health and safety, which is very straightforward. Are there noxious odors? Are there harmful noises? Does it impact, significantly impact the traffic safety of the area? The third is impact to adjoining property, and that's specifically impact to property values. Oftentimes in these types of presentations, or when these are applied for, the applicant will hire a appraiser, and an appraiser will testify as to impact to adjoining property value. And the final is just compliance with all ordinance regulations, or the applicable ordinance regulations. Before moving on, just want to highlight that, as I said, the applicant will oftentimes, or pretty much all the time, hire experts to be there to present these and to testify to meet these standards. It is, they have to provide competent expert testimony to meet those. If they don't, the permit is not issued. If you are opposing one of these special use permits, you also have to have those experts. You have to have competent expert testimony to rebut any of those that the applicant has met, any of those standards that the applicant has met. And while the governing body may take into account or may be sympathetic to issues that are brought up by neighbors, those really truly should not factor into the final decision. So if an association looks to oppose a special use permit, you need to understand that experts will be involved. You will need to have your own expert to rebut that if you choose to oppose it, because that is the only way to challenge a special use permit. Again, if the applicant meets those standards. So now we'll move on to those two problems that Adam highlighted and I highlighted at the beginning of my part of the presentation, which are the first being the internal problems. Again, these are going to be probably less common. They'll probably be less significant. Again, it also may not be an association issue. It may be an issue that pops up with a singular member. Again, if that happens, communicate with the municipality and defer to them. Defer. Let them do their work. You stay out of it. Let them be the bad guy. And you can kind of, again, you can just sit back and be more of a spectator or facilitate communication rather than trying to enforce municipal regulations. These will oftentimes be internal uses by the association or association members. When I say that, that means, again, it's going to be things like short-term rentals, which are oftentimes prohibited in certain areas of a municipality. It'll be occupancy requirements. It'll be leash laws, for pets. When people go and want to walk their pets, what is the requirement for that dog or cat to be leashed? And then there'll also be the development standard, which again are going to be things like, what are the fencing requirements? What are certain height requirements? For the association, what is the signage requirement? What's the maximum height of a sign? Does it have to be a monument sign? All of those are common, and those will be probably more nuanced, a little bit more selective. Again, it may just be a singular member that has that issue, and so it may not be as impactful to the association as compared to the external problems that an association may face. Those external problems are going to be more common, and they're just going to be more significant because they may impact the association as a whole, and it's likely to impact a greater amount of the association members. And when I say external, that problem will be when there is a proposed development or an application to rezone a piece of property that is adjacent to or nearby the association. There is no one-size-fits-all approach to these issues. That's one of the reasons why I have a job. If it was cookie cutter, I would be out of a job and likely trying to do my best to make the MBA as a slow, unathletic, and out of shape 29-year-old. So I'm very glad that it is not cookie cutter. I'm very glad that it is. It varies, but I want you to know that so that you're not surprised when these issues come up, if either the approach that you take or the approach you receive or the advice you receive from council varies, because they are very, very unique, and they're different from application to application. Again, that variation, it's going to depend on, the variation and how you approach it is going to depend on what is the request. Are they looking to do a standard rezoning? Have they proposed conditions? Is it a special use permit application? It'll depend on what those conditions are. Are the conditions robust? Have they put a lot forward in the conditions? Have they been very thoughtful in conditioning the property? Or have they just kind of put out basic conditions that really don't help preserve or protect the association and nearby property owners? It's going to depend on the jurisdiction. Again, that's why we want you to have a good working relationship with the planning department, with those governmental bodies that we highlighted, because you'll be able to get a sense of what is their appetite for development, for certain development, what is their appetite for a specific application. And then finally, it'll depend on the developer. What is the developer like? What is the applicant like? Are they looking to work with adjoining property owners? Are they people in the community that the association or adjoining property owners know? Or are they, what I would call a Johnny come lately who's looking to make a profit and develop a piece of property? Those can really impact both how an application is framed and how we address an application. And so in looking at that, we're now going to get to probably the most important thing, which is how do you challenge a land use request? In dealing with these external issues, that's really where the association is going to get involved. the association is obviously going to want to assess whether or not it does want to challenge a land use request. The association may look at a request and be okay with it, and then it's not an issue. The association can sit back and let that request take its course. However, for those where the association is concerned or members raise issues to the association and its members can then begin to challenge that request. And with this part of the presentation, we want to give you, again, kind of best practices as to how to get that started, or at least what that process may look like, so that you're not scared or you're not in the dark when facing this. So again, because a lot of these are legislative decisions, there's a lot of legwork that needs to be done at the beginning. So step one is you will receive a public notice. There should be a notice in the mail to the association and association members and all nearby landowners, and they should receive that outlines the details of the request. And then there'll be posted signs, which are called Z signs. They're pretty, you can't miss them. They're fairly ugly signs that are posted right outside of the subject property, and those will inform you as to the nature of the request and any public hearings. So please be on the lookout for that, so that you are not caught off guard or you're not hearing second or third hand. Make sure you pay special attention to those things in the mail, because they will have information. I know it's easy to throw those out. I do that, but I encourage you to stay on top of it, because if you stay on top of it from the beginning, the process becomes a whole lot easier. Step two is, once you receive that notice, or once you get word that there is a rezoning that may impact the association, I would encourage you, first thing is to contact the planning department. Contact them, discuss with them what the nature of the request is, and request all application materials. That's not just something that an association does. That is something that I do. When I get a new matter in, a new land use matter in, I conduct some basic due diligence that I'm familiar with the ordinance. And then I contact the planning department. They are going to be your best friend. They will help you through this process. They're dealing with the ordinance on a daily basis, and they've seen pretty much everything under the sun, as it relates to the ordinance. So they are just in a good position to advise you as to what's going on, and then you can kind of have a frank discussion with them and see kind of what they're hearing, what their thoughts are on the application, if there are proposed conditions. You can get all of that background information. The next step, which is step 4, or I guess step 3 actually, is due diligence. Once you have all that information, you've requested the application materials, which are part of the public record when they're submitted. So you should have no problem accessing them. You need to conduct due diligence. My recommendation is that you have legal counsel perform comprehensive due diligence on the proposed rezoning. Land use counsel like myself is, again, very familiar with the UDO, with the LEO, with the comprehensive plan, and we'll just know the ins and outs of how to navigate that efficiently and to get a work product and to get information to you most efficiently. I would also, again, get counsel involved as soon as you can on this. It's a lot easier for me to assist a client when I'm kind of starting from the beginning rather than joining midstream. We obviously do that. I've done that numerous times, but it makes the process easier. It makes it more efficient for myself and for the client. So I would encourage you to be very upfront with counsel and to get them involved early on, especially if you see this being something that you're going to want to challenge down the line. So again, challenges will be project specific. You're going to want to determine, again, does the association want to challenge this? Is this something that the association is concerned with? Or is it something that the association is fine with? And so you're going to want to assess that, first of all. Second of all, you're going to want to assess whether or not you want to challenge this outright. And when I say challenge outright, whether you're opposed to this development altogether, that there are no conditions that can make this acceptable to the association, that there aren't any changes the developer or applicant can make, but rather it's just this type of use or what they're proposing, or the density or the height, whatever it may be, is just not acceptable. Alternatively, you're going to want to assess if it is something that you think is workable. You're going to want to assess potential conditions. Again, that can be conditions based upon the density, or conditions restricting the height of buildings, conditions restricting access to the property, conditions restricting fencing, requiring fencing. A lot of common conditions deal with screening or buffering, requiring certain plantings to buffer and provide a buffer in between that development and adjoining property. Another common one is setbacks, is how far back does a structure have to be from the property line in the development. These are all common, and so you're going to want to really take some time to discuss within the association what is important to the association. If it's something that is potentially workable, what would you like to see be part of the application? Because then you can take it to the developer, to the applicant, and then ultimately to city council or county commission, and raise those issues, and it allows you to best position yourself in challenging these things, which is also why it's important to really be on top of things from the beginning. Those negotiations are much more likely to be fruitful, and you're much more likely to get what you want out of those negotiations and discussions with a developer or with an applicant at the outset, rather than down the line or during the public hearing process. And so now we'll get to really kind of the substantive challenge. And before I jump into that, just want to emphasize one more thing on the last slide, which is that assessment. I can't emphasize enough that having a frank and honest assessment on what the association wants and how it wants to proceed is vital. It will chart the course for the association. It will impact how the association proceeds. It will impact how your legal counsel proceeds. And it will shape how that process goes about. Typically trying to be cooperative, or at least attempting to work with the developer is a good way to go. One, because you can get those conditions that I discussed about. And two is because if you reach out and the developer gives you the cold shoulder or refuses to talk to you, that is something that when we go to council or zoning commission, we can raise that issue with them there and say, we've tried to cooperate with them, we've tried to be a good neighbor, but they've not reached out to us. So it's a two-pronged benefit there to being proactive and trying to be cooperative with the applicant. That doesn't mean you have to agree with them or support their application, but I think you want to set the stage for showing that you're a good neighbor, and that will also benefit you if you are seeking conditions. So now we actually get to the substantive challenge of the land use request. You decided that you want to go and challenge this. How do you start? The first thing is community organization and involvement. You want to get people within the association, and you want to get adjoining property owners on the same page. And I can guarantee you, if the association has a concern, or as opposed to a land use request, there's going to be some property owner and probably a number of property owners nearby who have those same concerns and are similarly opposed to that request. And it's important to kind of get on the same page with these people, because in opposing a land use request, specifically a rezoning, which is legislative, having a show of opposition and having strength in numbers is invaluable to that process and to the opposition. It shows that there is a concern not only amongst one individual or one association, but amongst a number of people who are constituents of the individuals on these boards, and it makes it a lot more impactful when you present your opposition. 2, communicate with the developer. I've talked about this already. You want to be viewed as being cooperative with them or working with them and attempting to work with them. It will yield better conditions for the property, and it will put you in a better light when you actually ultimately oppose a land use request. Additionally, even if you are outright opposed to the development, I would encourage and advise that you communicate with the developer on potential conditions, because you really want to hedge your bets, because they may be successful in getting their application across the finish line, and you would much rather have an application approved that has numerous or several conditions that limit what they can develop or how they can develop it, than having something where they just get a standard rezoning that does not limit them at all and allows them to go forward under just what is provided in the ordinance. So hedge your bets, be smart, communicate with the developer, see what conditions can be had, and see if the developer will be open to adjusting their application or amending their application. The final challenge or the final kind of part in challenging a land use request is actually the public hearing. This is game time. This is what I live for in doing this, which is where we will develop a presentation to challenge the request. I love to use PowerPoint. I think pictures tell 1,000 words. And you get up and you present to, again, initially it'll be the planning board or zoning commission, and then finally it'll be city council or county commission. And really what you want to emphasize is the impacts to the association, the impacts to the surrounding area, and also to the extent you can highlight how this request is inconsistent with municipal law, how it's inconsistent with the UDO, how it's inconsistent with the LDO, how it's inconsistent with the comprehensive plan. If you do all of those things, your challenge will be best positioned to be successful. There's no guarantee of success. City council and county commission will do a lot of different things. I've had cases where I thought we had a slam dunk, it was going to go well, and they latched on to one thing that I thought was not important, and they just decided to go with it. So it can be unpredictable, but this is how you best frame up your challenge to a land use request and how you best frame up protecting the association when there's a concern about a development. Here's one of our, the next one is one of our last slides, which talks about land use enforcement. Again, defer to the municipality, always defer to them. They have an enforcement regime there to handle issues that pop up. So defer to them, communicate with them if you have a concern, but let them take the lead on all of this. The first bullet point there highlights that municipal land use regulations and enforcement specifically are inconsistent. And I put that on there for 2 reasons. One is when you go from city to city, town to town, county to county, how they enforce land use regulation will change. No one city, no one town is the same as the other. Some are very aggressive at enforcing land use issues or non-compliance with land use regulations. Others are going to be much more lax. But 2, you'll also see inconsistency within those cities or towns, and it just depends on who you get on the other side, who is in charge or who is responsible for that issue within the planning staff. So just be aware of that. It can be frustrating at times, but it's part of the process, and just understand that there may be some inconsistency. In terms of what kind of sticks a municipality has to enforce its land use regulations, those will typically be things like written warnings or verbal warnings to the property owner if they're non-compliant. It'll be fines that will escalate from a first offense upwards when you have a third or fourth offense. And what I'll say is, if there's an ongoing issue with an adjacent property owner, keep communicating that with the planning department. Let them know what the issue is. If it's something that they're already aware of, but you haven't seen any change, I would say, I would advise you to continue to communicate with them. Obviously, do that in a respectful way. Give them enough time to address the issue. But again, they may not be as on top of it as we would hope they would be. So do not hesitate really to stay on top of that, and don't fear communicating to them and following up on those issues if you're not seeing additional results. Finally, we'll get to just some of the land use best practices, and these really touch on a lot of the things I've already talked about. First and foremost, again, familiarize yourself with your jurisdiction and with the UDO and LDO. As I said, I'd advise you to go ahead and have that saved as a PDF, have it for a quick reference. You certainly do not need to memorize it. You certainly don't need to read it all. It is quite boring. It is not exciting reading, but it's good to be familiar with it. It's good to have a working knowledge of what is in it in terms of topics, so that you can, when you have an issue, go to it and be able to find the information you need easily. To understand your property's rezoning and the zoning in the surrounding area. Have an idea of what is permitted, what the use districts are, and what is allowed to be built in that area, so that you can anticipate potential issues. One of the things that's important to know is that the use district or the land use designation, it runs with the land. So a property owner may come and go, but whatever that district is and whatever is allowed or not allowed in that district is what will be enforceable. So understand your property zoning and that surrounding area, so that you can see kind of what may be coming down the pipeline and anticipate issues. Third, again, I can't emphasize enough that having a good relationship with your planning staff will save you a lot of time, and it will just make you better positioned to challenge issues down the line. And make sure you pay attention to all notices. It'll allow you to get in front of an issue. It will allow you to get counsel involved earlier, and it will best position a future challenge. So with that, I think we will answer some questions. Again, thank you all for letting me speak on this. I enjoy being able to help associations with these matters and being able to advise you on this. And I know that it impacts a lot of people's daily lives. So that's that's one of the reasons I got into it. So thank you.
Thank you so much, Clint. And thank you, Adam, for kicking things off for us. We did get a couple of questions in during the presentation, so I'll just dive right in with the first one. And that question is, does a zoning map reflect only overall approved zoning, or also any zoning variances occurring within a specific zone?
So that's a great question. The zoning map will show you what the district is. And so you'll get an idea of what the use district is. And typically it will also show whether or not it is a conditional zoning. It will not show variances. Typically it will not show the conditions on GIS. Some municipalities are better. Some of them provide better information on GIS. Some don't provide great information whatsoever. Some of that information is more publicly available, and then you'll run into smaller towns that just don't have that capacity or the ability to put that information online. So what I will say is the zoning map will be a first reference for you. Check it to see what the district is. Check it to see whether or not it is subject to any conditions. And then if you want to inquire into what those conditions are, or if there are additional limitations, reach out to the planning department. Have that pipeline with the planning department so that you're comfortable talking to them. They know you, and they'll be able to answer your question.
Thanks, Clint. And then the second question is a question, and then it provides an example. So I'll read through that. So the question is, how much communication should be provided when we get a zoning notice? And the example is a rezoning a parcel across the street from community that this person managed is received. All of the homeowners get the same notice, correct? Or should the CMCA or the board involve itself or leave this up to each homeowner to look into?
That's another great question. There are requirements by law that are statutory, and then they're also you'll find them in the UDO or LDO that require certain notice, and it's all property owners. within a certain, essentially a certain radius. It'll typically be 600 yards, 500 yards. It can vary. We'll receive a mailed notice, and that mailed notice will be a form letter to that property owner. So specifically, all of the members of the association or all property owners within the association should receive it if the municipality is doing what it is required to do. If the association receives it and thinks that members may have concerns about it, I would say provide it to your members. Make sure that you fully disclose it to them so that they're aware of what's going on. I think you want to be fully transparent with them because ultimately they'll see signs that are posted or they'll get wind of it. And I think you're in a much better position to go ahead and provide that to them up front than to try to explain why that was not provided when you received the notice. So they should receive the notice, but I would say if you have any concerns that they have not been received, go ahead and provide it to the members and make sure they're aware of it.
I'm going to chime in here on the second part of that, which I agree 100% with Clint that you absolutely should get that notice out to your homeowners. However, you have to be very careful. The association cannot stand up, zoning hearing, rezoning, special use permit, any of these hearings and say that they represent all of the homeowners within that subdivision. The association can only represent itself as a body politic. And if those owners want to be represented, they have to do so on their own. And the reason that I parse this out is that, remember what we said at the beginning about what the association's purposes are. They may be very different than what someone cares about in terms of rezoning, all right? And I'll give you an example. Most municipalities, their ordinances will allow a temporary sales office for a developer to have in a residential area, as long as a certain percentage of the lots are unsold. But usually the developer doesn't really pay attention to this and will leverage that sales office and sell it to another realtor or someone to give them exclusive use rights in that community. It may not be an association matter. It may only be the people that are surrounding where the real estate sales office that are actually the ones that can challenge it, right? So you just have to be really careful about that. So that's my 50,000 foot view when it comes to sharing. It's good, but participating may not be a good use of association funds or even authorized.
Thanks, Adam. And we did have another question that came in. And why would a management company not be notified for a zoning change next to a property that they manage?
The association should be receiving that notice. Again, it's not a perfect system. You're subject to human error with notices going out. The association should oftentimes receive it. But it just may not be something that is in the system for the municipality. It may not be something that the municipality has, again, in its system. And so they may be sending it out to homeowners within the association, but not to the association's office or to the association's mailing address.
So much, Clint. So that was all of the questions that were submitted, and we will wrap things up for the day. Thank you again to Clint and Adam for their presentation. For those of you in attendance following the webinar, you will be sent an email with a list of articles related to the issues discussed today, a recording of the session, a copy of the slide deck, and a link to sign up for our community association alerts. We so appreciate you taking the time to join us and hope you're able to take some of the information you learned today and apply it to your own organizations. Thank you again, and this concludes today's webinar.
Thanks, everybody. Great to see you all, or at least see that you're in attendance on the screen. And thanks so much, Jen. Thanks, Clint.
Thank you.
Bye.